Having said those things, I did want to just lay out for people who may not be aware of it what the status of the case is with regard to the Third Circuit. The case now sits before 3 judges of the Third Circuit in Philadelphia. It was heard last May. It's a long time for them to be discussing what their verdict is, which suggests that at least it's probably going to be a divided verdict, 2-1. But which way that division will go on any of the 4 issues is hard to say. There are 4 issues before the judges. One of them, which I'll dispense with first, is and which is probably the safest one to make a prediction on, is the effort by the District Attorney's Office to get Mumia's death penalty reinstated. The death penalty was overturned by Judge Yohn in 2001, and the grounds were that the jury form that they have to decide whether there's mitigating circumstances was ambiguous and confusing, and that they then would have said the wrong thing, and that there are no mitigating circumstances. And Judge Yohn found that form and the judge's instructions to the jury were wrong and confusing, and so he overturned the death penalty. So if that's upheld, then Mumia will not be put to death. That'll be it. I mean, it could go to the Supreme Court, but it's really, at that point, unlikely to be overturned if the appellate court upholds that decision. The other way it could go would be that the decision would be overturned, in which case the DA would have to decide whether they wanted to retry the death penalty, not the guilt, but retry the death penalty. They'd have to pick a new jury, they'd have to have a new trial just on the penalty. So conceivably he could be put back on a date for execution. I think it's unlikely. I think the judge's decision was really on sound ground. There's a lot of precedent for it. It would be astonishing if they overturn it. Then it turns to the 3 avenues of appeal that Mumia has for a new trial. Two for a new trial, 1 for a new Post-Conviction Relief Act hearing. The two for the new trial are jury bias, racial bias in jury selection, and the other is the statement made by the prosecutor in his summation to the jury that their decision really wasn't that serious. They didn't need to worry about it because it wasn't final. That was his term. Your decision is not final because there will be appeal after appeal. So on the first one, the jury selection, it is accepted as fact by both sides that the prosecutor used 10 of his 15 peremptory challenges, which are challenges he doesn't need to give a reason for. He used 10 of 15 available to him to remove black jurors from the jury who had stated that they could, in fact, vote for the death penalty. And so on its face, that would suggest that he removed 10 people from the jury because they were black, and possibly 11, but they stipulated, both sides have stipulated to 10. This would be in accordance with a pattern that was true of the prosecutor in the case, Joe McGill, who later studies showed had rejected 58% of black jurors in his 6 death penalty trials. 58% of all black jurors who were presented at his trial using peremptory challenges, and only 22% of whites. So he was more than twice as likely to strike a black person than a white person. It's also consistent with 2 terms of the District Attorney's Office under Ed Rendell, who struck 74% of blacks and only 25% of whites in all of his prosecutions of death penalties, including Joe McGill's. So there's ample evidence before these 3 judges that the DA's office was racist in intent on its selection of juries. It deliberately excluded blacks, which is illegal, and which under the Supreme Court requires a new trial. If there's a finding by the judges that there was racial bias in the jury selection, that's it. There has to be a new trial, period. Because you cannot have a fair trial in which people are rejected for either religious or race reasons. So that's a very strong argument for a new trial. The second one is a little bit iffier because it hasn't overturned a guilt-based trial at the Supreme Court yet. But at least one judge seemed astonished when this was presented, that you could have a fair trial under these circumstances. That's where the prosecutor says to the jury, your decision doesn't matter. And I think there's an interesting point here, which my brother Linn Washington discovered, and that is that there's a special exception for Mumia in Philadelphia and in Pennsylvania, because in 1986, the Supreme Court of Pennsylvania overturned a death penalty because Joe McGill, this very guy that prosecuted Mumia's case, said that to the jury at the penalty phase. Said, don't worry about sentencing him to death because it won't be final, there'll be appeal after appeal. And the Supreme Court ruled that that was removing a sense of responsibility on the part of the jurors, and therefore they granted this guy a new penalty phase hearing. Mumia came up, they rejected it. They said, doesn't matter. And then in, I guess 2000, they faced the same, it was a year later. They faced this exact same case again with another case, and they ruled that you couldn't have a fair trial, and that in all future trials, if a prosecutor said what Joe McGill said in Mumia's case, the trial would be unfair. So there's only one exception to their decision, and that's Mumia. It's the Mumia exception, and there are a number of those in the course of this whole case. So the last issue that could ultimately get Mumia a new trial is the argument that at the post-conviction hearing in 1995-96, the judge in the case, who was the trial judge, Albert Sabo, was so unfair, so racially biased, and so inclined for the conviction that Mumia did not get a fair hearing of the facts of his case, a re-examination of the facts of his case. And that's absolutely clear. I mean, this was a situation where the judge had a witness arrested in the courtroom after she testified on a check-kiting charge that she'd already agreed with her attorney to appear on. They never arrest people for that, but he did it for show. He denied every single request for a subpoena by the defense to try to bring in witnesses. He interrupted and cut off testimony whenever questions started moving into areas that undermined the original trial testimony, so that anybody who was trying to recant what they said before was unable to do it. There's just an endless array. It took me, it took me 300 pages in my book to list all the abuses that occurred in this case. So I can't go into them here, but it's clear that anyone that looks at this fairly, that Sabo completely poisoned the effort in 1995 to look at the fairness and the facts and to add new facts to this case. So if these judges are fair-minded and not under pressure to do the Mumia exception, they will have to order a new PCRA to allow this to be done fairly. That could either be done back in the municipal court, or it could be done at the federal court level, which would be better because it would be fairer. So I think that lays out the case pretty clearly, and I can answer questions later if you have them.